Good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Thursday, February 26, 2026 at 1:05 in the afternoon. So we're going to utilize this time until the floor to start looking at a redraft of H211, which is data broker bill, and to take some testimony. So we have with us our legislative counsel, Rick Sagal. Rick.
Good afternoon. Rick Sagal with the Office of Legislative Counsel. So we're looking at draft 4.1 of H211. Share my screen. So the changes from the last draft are highlighted in yellow, and there's really kind of two categories of changes here. One category is there were some recommendations from the Department of Financial Regulation, which I think you're hearing from them today. Is that correct? So they'll explain those changes, why they think they were needed. And there were some updates to the deletion protocol that consumers would have through the bill provided by a data broker. So I will just speak to those changes. And of course, any questions about the overall scope of the bill, happy to answer maybe after I go over those changes, if that works for the chair. Okay, so we're going to go down to page 8. And this is a request from DFR. And this is fairly substantial when it comes to the Security Breach Notice Act. Currently, this definition of personally identifiable information under current law means a consumer's first name or first initial and last name in combination with one or more of the following data elements about a consumer. So again, they'll testify as to how they want to change this, but it makes this category much wider in scope to where no longer would you need the first name or first initial and last name in addition to something else. Now it would just be any one of these data categories: social security number, driver's license. And again, they'll testify as to why that is and why they think it's necessary. Just for the Security Breach Notice Act that's already in law. Okay, next change is on page 10, the definition of processor. On the last draft, that last word highlighted business was data broker. So I'll read the whole definition. A processor means a person who performs any operation or set of operations, whether by manual or automated means, on brokered personal information or on sets of brokered personal information, such as the collection, use, storage, disclosure, analysis, deletion, or modification of brokered personal information on behalf of a business. The recommendation here is to change it to business because later on in the bill, you'll see that there's a exemption from the deletion mechanism if you're a processor of a data broker. So here it was decided that maybe this should be a broader definition. It shouldn't just be a data broker processor. It should be any business who has their data being processed. This will make more sense in context when I get down to the deletion language. Okay, going on to the next change, which is further down on page 16. This is the Security Breach Notice Act. This is again a request from DFR. So currently, when there has been one of these breaches, we haven't talked a lot about this Security Breach Notice Act. It's current law. But if there is one of these breaches, any business that collects data, which is a very wide scope, includes the state and state agencies. So if a entity has a security breach and they have to provide notice to consumers, one of the ways to provide notice is through telephone notice, calling them. And there's current law. It is again, you'll hear testimony that the DFR is concerned that a lot of times the businesses that have the breach leave a voicemail very quickly without trying to contact the consumer. So the request is if you provide telephonic notice or telephonic, for those consumers whom the data collector has a valid phone number, is new language, provided the telephone contact is made directly with each affected consumer and not through a pre-recorded message. And further provided that the data collector makes not less than 5 attempts to contact the consumer for a live conversation before the data collector may leave a voicemail providing information about the breach. So 5 attempts before you leave a voicemail. Subsection C, just adding a heading that no other substantial change, just so it's easier to read and understand the statute. D, same thing, adding the subheading of exception to the notice requirement, no change to the law. E is the HIPAA compliance part of the Breach Notice Act. So again, DFR requested some language, and the substantial change is down here on page 19, that if a business or entity claims that they don't have to provide notice or that something else requires them to not follow the Security Breach Notice Act because of HIPAA, they must provide notice to the AG or to DFR that this breach happened, not to the consumer, but to DFR or the AG, along with a compliance of certification of compliance with HIPAA notifications. I'll let them explain the details of that. Subheadings added to subsection F and G, no other changes, waiver and financial institution. So 2436, I have a brief comment here. There's no change in the draft of this, but if the committee wants to update the definition of personally identifying information, I'm going to suggest, and it's of course up to you all, that this new statute not be included in the bill. So let me give you some background. This notice 2436 is almost word for word the Data Breach Security Notice Act, what I just went over, 2435. It's almost word for word the same. This part of the bill was added before there was discussion about updating the personally identifying information definition, and is maybe not necessary legally because, go back up. This 2435, the notice of security breaches, applies to every data collector, which likely includes most data brokers. So data brokers already do have to comply with 2435. The 2436, the new Breach Notice Act, would apply to brokered personal information. That's the only difference, is that if there is a security breach of brokered personal information, at this point, as this bill is written, if you are content with those two definitions are very similar at this point. So what I mean is personally identifying information and brokered personal information are very, very similar. And in my opinion, legal opinion, you don't need a second act just for data brokers. And that's, again, it's a policy choice, but if you want to make things simple for businesses, I don't think you need this second act that really would add no meaningful protection to consumers. That's my legal opinion, but of course, and that's not in this draft because it's a complex draft and I keep reading it. I find things that we need to talk about, and that's my latest thing. Happy to answer questions about that, or I can keep moving on.
I'm all about simpler.
Yeah, and again, it's assuming that you all want to keep these definitions kind of as we're directing them to, but something to keep in mind. Okay, skipping.
Okay, just one question. So, what's the law, what's the section of the law that this would be duplicative of?
So 2435, 9 VSA 2435, it's literally right before this one.
And you're saying some of the cleanup in the definitions are harmonized, it would further harmonize what we're talking about here? No. I had one question about the definition then. In the definition of, I think it was personally identifiable information. Yep. Page A. You struck through consumer's first name and last name. Why would that not be considered personally identifiable information?
So this current definition requires those two things to be present along with a third data element. Yeah.
I get that.
Yeah.
But why wouldn't the consumer's name be sent? I'm missing something, I think.
No, I think I get what you're saying here. I think he's saying the consumer's first name, first initial, last name is struck in, but it's not added to the list of
As
elements.
a list of information.
Is that what you're saying?
So is someone's, so that's a policy choice. Would you want someone's name to be a data breach if just their name is alone? Is that something that is personally identifiable
Oh,
information?
yeah, because it's Warner.
Right.
So maybe it's a question for DFR, because this was a request.
Oh, okay.
But when we put this, when we created this, that's PII wasn't PII if you just had first name or first initial, last name. But in combination with the social security number, driver's license, and it becomes personally identifiable. That's the way we were looking at it.
Mhm.
How many years ago we put this?
Okay. I'll think about it.
Yeah, let's ask DFR.
And this is something that I think we should all think about some more. I'm just thinking that it's not even legally necessary to have a separate one just for data brokers.
Oh, I get that.
Yeah,
I get that. point.
yeah, but maybe the definitions need additional work, you know? Happy to have that conversation. Any more questions about the security breach notice language? Okay, so we are moving down to the next change, which is on. Did that one already? Just added a subheading on page 24. No change to the, oh, that is, I do want to mention one thing. Sorry. I didn't highlight it. DFR contacted me about something that I missed, and I want to set it up for them. So back to 2435, it's not in the bill, so you won't see it here, but there's language in the Security Breach Notice Act that, in fact, I have it here on the, let's do this. Okay, so in the enforcement section of the Security Breach Notice Act, DFR highlighted that currently it's only if a entity, a data collector is registered with DFR, and they're going to suggest that it be regulated by DFR and not just registered by DFR. So I'll let them describe why that would be beneficial for their work, but that's something not in this draft that I looked at it, I didn't have a problem with it, but something that you all should have a conversation about. Okay. On page 25, you've seen this before. This is me adding in a technical correction that is in H650. I'm also putting it here. Hopefully one of the bills moves so I can get this item fixed. This is just correcting chapter to subchapter. You're going to see it in maybe 10 more bills by the time the session's over. And one of them will make it through. Yeah.
Miscellaneous.
I mean, just the law of averages, right? At some point. All right, on page 31. Okay, this is the deletion language. So there were no changes to the registration piece. A data broker still must register 30 days after becoming one, and then once annually, they must set the bond. That language from the last draft is still in this draft. We can have a conversation about it, but let me maybe get through the new language first. So subsection C, a data broker shall maintain a conspicuous page on its website where a consumer or an authorized agent of the consumer has the ability to request the data broker delete the consumer's brokered personal information free of charge. B, delete the consumer's brokered personal information not later than 30 days after the consumer makes a deletion request, unless the data broker denies the request pursuant to another exception down below. Notify the consumer that the consumer's brokered personal information has been deleted not later than 5 days after the information has been deleted. 2, The web page maintained by the data broker pursuant to this subsection shall describe how a consumer may exercise the consumer's right to delete their information, including the process for the consumer to appeal the denial of a deletion request pursuant to a later subdivision. They shall adhere to the accessibility and usability guidelines recommended by the Americans with Disability Act and the Rehabilitation Act 1973, and employ design practices that facilitate easy comprehension and navigation for all users and that are free of any dark patterns. 3, this is language that was in the last draft, but just to tee it up, a data broker may deny a consumer's request to delete the consumer's brokered personal information when they make a request to the extent that, I'm going to read these again, the retention of the consumer's brokered personal information is required by law or is required to comply with a civil, criminal, or regulatory inquiry, investigation, subpoena, or summons. The brokered personal information is used by a consumer reporting agency to furnish a consumer report pursuant to the Fair Credit Reporting Act, necessary to investigate, establish, exercise, prepare for, or defend a legal claim, strictly necessary to fulfill a specific legal requirement on behalf of a business to which the data broker is bound by a written contract to fulfill that legal requirement, used to prevent, detect, protect against, or respond to security incidents, identity theft, fraud, harassment, or to preserve the technical integrity or physical security of systems, or investigate, report, or prosecute those responsible for any such action. These next two are new. Data that is collected or used for purposes of the National Precursor Log Exchange or its equivalent. These are the pseudoephedrine checks that when you get Sudafed over the counter, they run your ID. So that information would be deemed not worthy of deletion. Or 6, processed solely in the data broker's capacity as a processor to a business with which the consumer has a direct relationship as that term is defined in this bill. And let me show you what that definition means. Okay. Direct relationship means that a consumer has intentionally interacted with a business for the purpose of accessing, purchasing, using, requesting, or obtaining information about the business's products or service. A consumer does not have a direct relationship with a business if the purpose of the consumer's engagement is to exercise a consumer right or for the business to verify the consumer's identity. A business does not have a direct relationship with a consumer simply because the business collects brokered personal information directly from the consumer. The consumer must intend to interact with the business. A business is still a data broker and does not have a direct relationship with the consumer as to the brokered personal information the business sells about the consumer that it collected outside of a first-party interaction with the consumer. Okay, that's the deletion language. 3, this is from the last draft, but I'm going to read the, sorry, that was already read. Here we go. So we're down to 4 and 5. 4 is previous language. That brokered information retained due to, let's see. If they deny it due to one of the exceptions, it must be separated or segregated from data used for any other purpose. It deleted immediately upon the expiration of the legal or contractual requirement and not used, sold, shared, or processed for any other purpose. Okay, 5 is new. A data broker shall provide the consumer with the ability to appeal an instance where the data broker denies the consumer's request to delete their information, as long as it gives the consumer 45 days after the consumer receives notice that the data broker has denied the deletion request, is conspicuously available to the consumer, is similar to the manner in which the consumer submits a deletion request through this bill, requires the data broker to approve or deny the appeal within 45 days after the date the data broker received the appeal, and to notify the consumer in writing the data broker's decision and the reasons for the decision. requires a data broker that denies the consumer's appeal to provide information that enables the consumer to contact the AG to submit a complaint. 6A is also new. If a data broker is unable to authenticate a deletion request, the data broker shall not be required to comply with the request and this is a deletion request, and shall provide notice to the consumer or their agent that the data broker is unable to authenticate the request. The data broker shall provide the consumer with the additional information the data broker requires in order to authenticate the consumer. As used in the subdivision, authenticate means the use of reasonable measures to determine whether a deletion request is being made by or on behalf of the consumer who is entitled to exercise that request with respect to the brokered personal information at issue. And then you may remember the section, some other changes to the statute. Section 2 is the study from the Secretary of State's office about the deletion mechanism. You may recall that previous version of the bill actually required the state to provide that deletion mechanism, and it was converted to a study. The only change are the dates at the very end. The interim report would be due April 15, 2027. The final report would be due December 1st, 2028, to give them time to conduct that study. And then the interim report would provide the General Assembly with recommended actions for the 2028 session. Okay, questions about the changes or overall bill?
So it looks like you got a little bit closer to where I was with the exceptions. Back up to
Right here.
that section. Thank you.
Mhm.
So I appreciate that, whoever worked that out.
That's intentional.
That being said, though, there's direct relationship. So the direct relationship, can we go back up to the definition on that? Let's just, if you don't mind going through that direct relationship again.
It means the consumer has intentionally interacted with a business for the purpose of accessing, purchasing, using, requesting, or obtaining information about the business's products or services. The consumer does not have a direct relationship with a business if the purpose of the consumer's engagement is to exercise a consumer right or for the business to verify the consumer's identity. A business does not have a direct relationship with a consumer simply because the business collects brokered personal information directly from the consumer. The consumer must intend to interact with the business.
Okay,
Yeah.
so I think a consumer does not have the direct relationship with a business if the purpose of the consumer's engagement is to exercise consumer right. No, that's not what it is. Oh, business does not have a direct relationship. Simply because the business collects broker. I gotta think about this a little bit more, so. It just helps.
Other questions for Rick?
I'm not sure it does what I want it to do, but I gotta look at it now.
Okay, I'll hang around for a little bit in case questions come. Okay, I think I believe it too. Yes.
Whoa. It's okay.
Good afternoon, Mr. Chairman, committee members. For the record, Chris Delia, President of Vermont Bankers Association. Appreciate the change in schedule because I have to be across the hall for H385 in a few minutes. So in looking at this, I just want to offer some general comments and then get into the draft. And the general comments is I'm just trying to figure out how this fits into the broader discussions of privacy, which you all have the S bill, which I assume you'll be taking up off the wall after crossover. Because this seems like you've got some components of a broader privacy bill in this bill, like the deletion sections. So I'm just trying to figure out the path, if you will, and how those ultimately reconcile themselves along the way. When I looked at this bill, just a few general flags, if you will. On page 2, lines 10 through 12, you talk about biometric data. And in particular, digital or physical photography or an audio visual, unless such data is generated to identify somebody. So I would just call your attention to the fact that we do have cameras in our branches, and for law enforcement purpose, we would turn specific videos or photos over to law enforcement so that they can help identify who that potential or bank robber was. And we wouldn't want anything in your work to prohibit that use for us turning it over to law enforcement, because the whole purpose is to identify somebody in those cases. Regarding on page 5, line 4, and this gets back to the question of direct relationship. I guess what I'm trying to understand there and reconcile is the fact that we have customer identification procedures, and we may use an entity that's not a financial institution, but we have a relationship with, to help us vet that data that we've gotten on the individual for customer identification procedures. That has to happen under BSA regulations, knowing your customer regulations. So I'm still trying to understand how this interacts with that need that we have for identifying a consumer. The consumer has the direct relationship with us. We're trying to identify that consumer. They don't have that direct relationship with the entity that we're using, who may have maybe it's a crime database or something that we would be vetting. So I just want to make sure we're not doing anything there that would prohibit us being able to do that. On page 8, lines 13 through 15, I'll watch the tape on the personally identifiable information and the name and first name request from DFR. I've been just thinking about it. A date of birth isn't anything unless it's linked to somebody. I could come up with random numbers to make it look like it's a social security number, but unless it's linked to a name, it doesn't mean anything. It's just random numbers. So again, I'm curious as to what the proposal from DFR is in this sense. On page 10, line 1 through 3, and I guess I should also step back and say, first and foremost, we don't fit within the definition of data broker. But these are just things that I'm flagging in the bill for consideration, because it's also who we work with to provide access to commerce and services. But on page, again, 10, lines 1 through 3, precise geolocation. I've obviously listened to all your conversations about concerns of geolocation, et cetera. And the issue that I can see here is an IP address of where an individual is communicating with our website is a form of geolocation if I can determine where they are. And in the context of fraud, that's very important. So for example, if all of a sudden my account is being pinged by an IP address over in Italy, that's going to trigger something within the institution to say, are you in Italy conducting transactions? Or not? So it is utilized as a fraud prevention tool. And I just, again, wouldn't want to see any limitations on that from the perspective of valid uses. This is under, on page 14, data brokers maintaining reasonable procedures, and specifically, I'm looking at the top of page 15, parentheses 2. And again, I'm just trying to understand how this plays out. So we have a data broker that we have a relationship with. The data broker does not have a relationship with our customers, so there isn't that direct relationship. And the data broker has to have policies and procedures to certify the information is sought, et cetera, for legitimate uses. So is this contemplating that when we are working with a data broker, we are going to be responding to the data broker in this certification process? It's not clear to me if that's intended or not, because again, everything that we are anything that we collect from that data broker falls under all of our privacy regulations that we need to maintain and adhere to. So I'm just trying to figure out if this is setting up a system where if I go work with XYZ company to help provide the service to the customer, do I need to communicate with XYZ company the reasons why we have a legitimate need for the information or legal need for the information? Notice a security breach. Look forward to your conversations because I kind of had the same question in the back of my head as to the need for two systems. But the only thing I will just share with you as cautionary is the telephonic notice. And that is something that you may want to put a little more of a boundary around from the standpoint of what is the broker asking, if you will, if anything, of the individual. Fraud, as you know, we've had these conversations, is very active in the marketplace, and a tool that's used is the telephone to call the individual to say, hey, I'm XYZ. There's a problem with your information. Please provide me your information. And as soon as you do that, you've given XYZ your data. And we always caution people when they get calls like that to be very mindful that it could be fraud. So it's one thing to, I guess I'm trying to give you a heads up on a situation that you're going to get a call from a data broker you've never heard of. And if they're asking you for information to confirm who you are, I think you're setting them up. You're giving an opportunity for a fraudster out there to do something wrong, more so than what they've got today. So I would just ask you to be mindful of that in the way that the data brokers communicate over the phone with the individuals. Then I'm going to jump to page, really, I guess, pages 31 through 33, if you will. And my comments here are really focusing again on, we are not the data brokers, but we work with entities in the market that have data. And I'm still looking at this to make sure, and I don't know if you never get there, but to make sure that we have accounted for business to business transactions when individuals are trying to seek products or services. And I'll just give you a quick example. Years ago, we created the freeze unfreeze for credit reports. If I freeze my credit report and I forget about that and I go to buy a car, I'm going to get to the dealer to fill the paperwork out and they're going to say, we can't do this because you got a freeze on your report. Very easy to go back in and unfreeze the report. However, if we've created a situation where that individual who doesn't yet have a business relationship with an entity, but is going in to buy the car, and they've put requests out there to have their data deleted. I don't know the method for recreating that data so the individual can then conduct the transaction that they want to conduct. So part of it may be a premature deletion of data because they think that's the right thing to do, but they're not thinking about the ramifications of I need this in the business market, or I want to do this with this entity and my data's gone. So those are the concerns, or just an example of the concerns that I have. And this is, again, we're not the data broker. We feel comfortable with that here, but we work with entities that have data. And if that data doesn't exist, then consumers are not going to be able to pursue the services that they're looking for. On page 33, in lines 10 through 12, for example, and this is under the category of a data broker may deny a request for deleting a data. It says under, again, VI, line 10, process solely in the data broker's capacity as a processor to a business in which the consumer has a direct relationship. Does that solely mean they're only processing for that business? Does that solely mean something else? I mean, a data broker may have multiple clients out there, but I'm asking them to process something for the financial institution. So I don't know how that solely applies in the context of the ability of a consumer to eliminate the data. When you get into the other sections, as far as study of the accessible data deletion method, no issues, how they file with the Secretary of State, et cetera, no issues. Yeah, our concern is, again, and if I remember correctly, the individual from California stated it. And again, this is why I go back to the question of how this fits into the bigger picture. California did their data minimization piece after they had their comprehensive bill. And I think the individual from California said that, yes, you need to be mindful of the need out there and legitimate uses for accessing data for commerce transactions that are out there. And that's why I continue to look at those provisions that you've got on pages 30 through 33 to figure out, are they truly covering the depth and breadth of what you might have out there in the marketplace, or are there gaps that may create problems for consumers?
Question for Chris? Michael?
Yes. If someone has an account and they pass away, how do banks reach out to, what do they do with the account?
If there's a beneficiary named on the account, then we would we would follow up with the beneficiary on the account. So for example, my mother passed away, my brother and I were beneficiaries on the account. So as soon as my mother passed away, we were proactive in going into the bank. But if not, the bank would have contacted us.
So what if the information is not accurate on the system that you have?
And run into a challenge.
Would you tap into a data broker at that point?
I mean, conceivably, we would want to do some level of due diligence to identify what that deficiency is. and a way to correct that deficiency to do either what's right under rules and regulations that we have to follow or what's been identified by the customer on the account. Yeah, it could be any number of steps that we may have to take, relying on somebody that's outside of our institution.
So would you tap into a data broker?
Sure. I don't,
Okay.
depending on where the information resides that we need to get, I could see where we might have to tap into a data broker. Yes.
Okay, so under this bill, that would not be a direct relationship and they would not have a direct relationship with the banks, correct? The beneficiaries of the account.
They have a relationship with the bank. I have to really think about that because they've been named on the account by mom,
They've never,
but maybe they've got to go back and think about what's going to be the requirement to put a beneficiary on in the account. Because that beneficiary, I'm thinking, I can't remember if we have to provide information, if the beneficiary has to provide information to the bank. And if that's the case, then they've got the information that they're looking for. But in the event where that information didn't exist, there isn't that direct relationship with the beneficiary. Again, if it didn't exist, and therefore, under this bill, it's problematic because we don't have that direct relationship.
so in that case, let's say there's $10,000 in the bank account. You can't reach the beneficiary, what do you do?
After a 3-year period, we're required to sheet that to the state of Vermont as unclaimed property. And then it will sit out there as unclaimed property. And as the treasurer does on a regular basis, he puts information out to consumers, check the unclaimed property, and then I would go in and I'd say, oh, there's an account in my mother's name, and then I would follow up the treasurer's office, and I would have to prove to the treasurer's office that I'm Mrs. Delia's son to claim the property.
I don't think many people check unclaimed property. I might be incorrect on that, but my guess is not too many people check it. And it would be a lot easier if you were able to get correct information, correct?
I mean, it would be easier and beneficial to the parties involved.
Yeah.
If we could get them their, in this case, the $10,000 sooner rather than waiting 3 years for the unknown of going to the state. If those circumstances can be resolved and we need to rely on a third-party data broker to help us with that.
And that's the kind of business that needs to be protected in this bill.
Yeah, Chris, if you have time, I would love to go through this with you later when you have time, because we were hoping, and thinking that this draft made it so there's exemptions for law enforcement, oh my God, fraud prevention, identity verification, and the Fair Credit Reporting Act. So that is the intent to try to do things. So if
That's
you're
fine.
feeling like you're not doing, I would love to work through it. Yeah.
Can I sit with you when you do that?
Yeah.
It could be a big tent with a number of people in that conversation.
Thank you.
Yeah, I mean, I agree. You've attempted
Yeah.
to deal with this in the exemptions. It's just, I don't think we're going to be able to account for every conceivable possibility that might come up. So I could see where we may have some issues out there. Time would tell.
I just want to, it's the legitimate business that I'm concerned about. I really don't care about any of the other stuff. I mean, wouldn't even have a problem with like saying, all data brokers are not allowed in the state of Vermont, with access to web portals and stuff. But for legitimate business, it's a real issue for me.
Questions?
Okay. You.
Yeah.
Hello, everyone.
Yeah.
Great, thank you. Good to see you all. David Hall, for your record, Director of the Business Services Division, Secretary of State's Office. Getting better at it. I submitted some written testimony, and while I've been sitting here, I updated it because everything I heard sparked a few more points I hoped to make, and I shared that updated version. So if it's not on your website, I assume it will be at some point. You told me your preference, but it seems like it'd be easier to look at the language together while I comment. Does that sound okay? So I have a link. Thanks, John. You know, those grooves in my brain are deep. We're all there. Tomorrow morning? Oh. So I think it should be allowing me. Being live stream. I need to turn off my. Okay, it's off. All right. Then I'm gonna share that draft. Oh, good. Here we are. That'd be super helpful. I need to have my setup, I've got two monitors plus my Nextera. This is great. Thank you so much. So my comments, I guess I want to frame in terms of, what my division, what our office does at its core, which is, receive and manage and then make available information, right? That's what we do. I think that's what our expertise is. What we don't do, or what I'm loath to do, is to cross a line over into being the people who do things about that information. And a lot of my testimony goes is connected to that theme, I guess. The first one, the first point, it actually comes up a couple of times in the draft, and it's minor, but I want to point it out for your consideration. So on line 3 here, so we're right now we're in the part of the bill that's talking about the stuff that the data broker needs to provide to our division when they register. And there's a whole slew of data points that'll come through. And then one of the things is a link to a page in the data broker's website that blah, blah, blah allows them to opt out of sharing and whatnot. And as a data point, I find totally with having that address be available as part of the package of data that they supply to us. My concern is if I read this literally, and if it's calling for us to have a live hyperlink embedded in our software or our system to an external party, there's a few concerns I have with that. one is that links break over time. And if we're looking at about 800 data brokers, inevitably some percentage will not work. And then they will not call the data broker or anybody else. They will call me and be like, the web page doesn't work.
Are you suggesting we put your phone number in there?
You can give them my direct line, which I don't actually know what that is, but I think it's 6511. So here's what I'm suggesting is we just modify that slightly to say a web address. So it's the URL of where they're supposed to go. And if we can maintain that as a live link, I will. I mean, I'm not opposed to in theory, but my concern is that if I can't guarantee with my vendor that I have a reliable way to manage that, and to also, the second part is ensure the safety that link is not corrupted, then I'm for it. If they say we can't safely do it because of our security parameters, then I'd like it to just be the URL address, but not a hyperlink. So that's a pretty simple one, I hope. So the next one, I am flagging in my number 2. I've couched it as clarifying intent concerning imposition and collection of fees for the failure to register. And that's on page 30, in lines 6 through 13. So you'll see here, the data broker that fails to register as required by subsection A is liable to the state for an administrative fine of $200 a day, an amount equal to the fees that were due during the period, and any reasonable cost incurred by the state in the investigation and administrative the action. I'm only flagging this because I just wanted to be in the record that we can definitely do current fees. We can do past fees. I'm pretty confident we can even collect back fees and that they can be calculated automatically by our system. We already do that for annual and biannual reports that are late by a number of years. We calculate how many years. It adds it up for you. It's very easy. But 1C, any of those costs of investigation and administration, those would be AG costs. And they would have to collect those. And I don't know what that looks like, but our working assumption is that we'll have an MOU with them on how this all shakes out. And that's great. We have a great partnership with them. But I just wanted to flag for your awareness as you're constructing this and you think about how this is going to work on the ground. There are certain automatic things that we will definitely be able to accomplish within the system. And then there are other things like this that will be them. And how that shakes out, I think we'll be pursuant to an MOU. But I wanted to put that there for you. Any questions or clarity needed on that?
Is it okay? Yeah. So is your concern about C that you don't know exactly what the costs are?
No, my concern is just to manage the expectation that I'm not going to be able to build the recovery of those costs into my system or into an administrative process on my side, that the AGO will have to pursue those through whatever mechanisms they pursue them. And I assume that'll require.
So you're looking at changing the language.
No, I just want everybody to know. Just flagging for to be sure we're all like on the same page with expectation. Sorry, Representative Wilson.
No problem.
Let me put that under the umbrella of managing expectations.
Yes.
I don't think there's a language change.
Nope.
Because
Nope.
the state can be any state agency and
That's what I'm saying.
And yes, and in subsection E of this 2446, the AG's office was and is charged with enforcement. So I think that's pretty clean. I think that's sufficient. Sometimes it says administrative fine or administrative penalty, and that can be construed to be one side or the other. I think we're going to map that out together. But that's sort of that line I'm drawing between like the parts that we can handle and the parts that they would handle. So the other next one, my 3, is the amendment of registration information and then process and duties concerning omitted information. So on page 30 here, lines 16 and 17, if you'll indulge me, I'm going to read subdivision 2 to you. So a data broker that fails to provide all registration information required in sub A4 of the section shall file an amendment that includes any omitted information not later than 30 days after receiving notice or notification of the omission from the Secretary of State and is liable to the state for a civil penalty of $1,000 per day for each day thereafter that the data broker does not file an amendment providing the omitted information. So there are several points I want to make on this. The first one is this question of omitted information. And basically the way that we'll build this out is that all of the stuff you told them to tell the state will be part of our online filing system, and they will have to provide a substantive response to it. And if they don't, they can't even check out. So it's highly unlikely that we're going to know about an omission of that kind. Like, you're not going to answer the question, do you collect the data of minors? They have to respond or they can't finish. Now, what they say, yes or no, and how they explain it is up to them. So, which leads me to the second point, which is the omission probably is going to come either from them realizing it or from some sort of public notice and complaint, or from the AG in the process of an enforcement action realizing you didn't tell us such and such. That's separate and apart from the mandatory boxes we've got to fill out. So for all those reasons, I would request that you not predicate this this duty to amend on getting notice from us and requiring us to discover something, because there are multiple ways by which that could be discovered, and we are the least likely to be the ones to discover it because, again, our system will require them to give us an answer. The other point this raises a bigger question, which is about amendments, and it's not explicit in the language, and I apologize, I missed this before, but we would really like it if you would add the duty to amend their registration information if something changes. And that will give us the authority to build an amendment workflow, and it'll give them the chance to change it. We run into this problem now where there is no amendment provision in the data brokers law, and they come back to us and say, we made a mistake, or we had more breaches that we wanted to update, and we have to tell them, frankly, there's no amendment. You just have to file a new registration. The problem maybe legislatively for you is that what I would also really want to see from you is a fee for an amendment that is not the $900 registration cost. So, if you want to just say, I don't care what, $25, $50 for an amended registration, something, anything. We want there to be a fee because it creates the friction of people not just coming in and changing things lightly, but we also don't want it to be in any way punitive. We just want it to be consistent with, other filing types, which are all over the place, but we talked about that last year.
Go ahead, John.
So for this section, that notification of the omission from the state, is that adequate?
I actually suggested here,
thanks.
and I'm borrowing your device, so you don't know.
It's a load.
That the omitted information would be, so not later than 30 days after discovery or receiving notification of the omission. So from whomever it comes, if a diligent taxpayer comes and says, you said XYZ about your practice, but you didn't, the policy that you uploaded didn't address what it was supposed to, then that's notice to the data broker, and they should update the record from our perspective. Yeah, so great question. That's what my proposal. I'm not wedded to the construct or the verbiage. You can do whatever you want. I just don't want it to be only triggered or triggered at all by us having to affirmatively reach out and say, we noticed XYZ, because it should be a self-executing duty to have adequate, accurate information.
I appreciate you putting on the record that I couldn't see.
Let the record reflect. I had already mentioned the express duty to update registration information if it changes. I think the question of this $1,000 per day civil penalty after 30 days, who's going to collect that? What does that look like? Again, I think that's going to be the topic of how we do that with the AG's office. That may be something that we could do if we built the system to calculate days, but that would be based on a report by the data broker. So I would be loath to do it that way. I'd prefer them to basically represent to the AG's office the date we discovered there was a problem, how many days were delinquent, what's the civil penalty, because that's really what the AG does. So that so 4 is the next subsection. My point for a collection of civil penalties and clarifying material incorrect information. Maybe I didn't even need to flag this one, but like the lawyer in me is basically asking like, well, what is material? What is material incorrect? Who's going to decide that? Because that's kind of a big deal. That is a huge jump in the penalty structure from you just forgot to tell us something versus there's something materially incorrect. And there's also a divide between just incorrect, you put the wrong address in and you didn't disclose your practice of collecting, employment data. So I'm not offering any suggestion to the language other than what's in my testimony, which is maybe it should be that same construct of either when you discover or you receive notice of some sort of problem. So correct the material incorrect information not later than 30 days after discovering or receiving notification of the incorrect information. And then, the rest I would leave to the AG's office to determine what's material, what penalties they face. But I just flag it. It gives me pause. Sometimes there's no way around that. We know it when we see it, what's material. So,
But Your Honor, it's not material.
I object. It's immaterial. Contact information for a data broker could be material. Like that could be a big deal. Or you tell us the wrong URL. That's a big deal, right? So on my 5th point, clarifying expectations for website information and SOS procedures. This pertains to page 35, subsection 2446D. I'm not, other than the URL piece again, I'm not offering or recommending any specific changes. I just want the opportunity to explain to you a little bit what this would look like in the real world as far as, I am recommending one change. So in D, again, I'm here on page 35, consumer rights web page. So Secretary of State shall create and maintain a publicly accessible page on its website, provides consumers with the following. So a downloadable spreadsheet of data brokers that have registered. We've already got that. That's great. All the information that they provide. And then the link to the page we've discussed, if you could see your way fit to make that an address. The 2 points I wanted to make are, we really operate 2 different websites and business services. There's the Secretary of State's website itself, which has a whole section of our stuff where we explain what kinds of businesses we regulate, what the requirements are for them, blah, blah, blah. And then the portal itself is where all of that is executed. So I just want you to know that the Secretary of State's website information pages would be where I would write all this stuff about what this bill does, what the rights are, et cetera. And then the execution of all that will be over in the portal. The downloading of the information, the searching for data brokers. So those will be bifurcated. And I assume that's okay with you, but I just wanted to be sure you're sort of cognizant of that. I think it satisfies the letter of the law. I hope it satisfies your policy pursuit. What I would D3 ask you to consider is this bit about an email or letter template. And my concern was only marginal the first time this language came through, but now that there is an appeals process, and there's obviously a lot of bases by which a data broker may refuse to honor a request, or they may not be able to authenticate the requestor. What it tells me is that this process is going to be a lot of back and forth, and it's going to be fact specific by consumer. There's going to be a reason the request wasn't honored. It's going to be different probably every time. And there's going to be a consumer who's upset and needs some sort of remedy, and only the data broker can supply it. All that in the face of this charge in 3, which tells us to prepare a template intended for a consumer to use to send to a data broker who has not deleted the consumer's brokered personal information. My concerns are twofold. The first is a form letter, a template is not going to be sufficient because these will be fact specific, frankly, oppositional procedures or correspondences between data broker and consumer. And second, I really don't, my division doesn't have the capacity, whether it's the expertise or the person power, to get sort of like sucked into a dispute like this. Do you know what I mean? I can see the public very much looking to us to act as their advocate, particularly if it's already reached the point that their request to delete their information was denied. And I'm really loath to be inserted into the request or the dispute process. And my fear is that the directive in D3 will put us right in the middle of it. So I'm asking you, it's your policy choice, but I'd ask that we not be responsible for that. Questions?
Yeah, I mean, I understand what you're talking about. But this part of the web page is sort of intended to give the consumer some understanding of what their rights are in the law? Or is that covered somewhere else?
And yes, the information page, totally, 100%. That's us, and we're cool with that on D1. D1, D2 with as long as it's a web address. 4, great. My only concern is 3.
Yeah. Where in that, is there something that describes either generally or in detail what consumers' rights are? I mean, if they're trying to construct a request to the.
Yeah, I mean, the pages I envision it would have the information broken up into what does the state require them to disclose? What is the data broker's duty to allow you to opt out? How do you do that? And we would refer them to the website, which is each data broker's process probably going to differ, but generally here are the 3 elements of your rights to request deletion.
Right.
Here's what happens if they don't honor it, then the time frame for, they have to tell you why. The right to appeal is 45 days, blah, blah, blah. I'm great to supply all that information. What I don't want to supply them then is a form letter that says,
Yeah, no, I get that.
you failed to do the thing, but it doesn't say why, it doesn't say how long, it doesn't say what your gripe is, it doesn't address the facts of your situation in any way. I don't think it terribly advances the process with the data broker, and I think it gets us directly involved in a dispute.
This consumer is going to assume your template is all they need.
And when it doesn't work, or what else, or this template doesn't work for me because what if they didn't delete my information because of X, Y, and Z? Should I still use this? Or I see that it says blah, 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 but what really happened in my case was blah, blah, blah. And how many times does that happen? I don't know. Maybe 5, but maybe 500. I don't know.
So I hear and appreciate your concerns. I'm wondering if it might be remedied, because I think it still makes sense to give the consumers the information that they need in one place, where at the same place where they would go to find this information.
Mhm.
But might it make sense to have a couple of sentences that say the Secretary of State's office is not X, Y, and Z, but the Consumer Protection Agency, and here's their phone number, could support? Just want you to noodle on that.
Sure. No, I can noodle it. I am
Maybe.
reluctant to volunteer them to also be the ones who get in the middle of a,
Maybe they help create the form.
sure. But
Let's process
Yeah.
it and talk about it.
sure. I appreciate the consideration.
Yeah, did you have a number 6 too? Is it this study or did you update that?
There is a 6
Okay.
on my notes. And the updated, I think, is already on there. So there's the points on this would, I think when Lauren Hibbert, my deputy, was here last time on screen with you, she suggested that we would use an expert to do the study and that we would want to hire somebody, so that would require funding. And I didn't know if that was part of your conversation, so I just flag it. The second piece is about the cost. And as I've written in my written testimony, I don't have a CR from my vendor right now about what their estimate would be, but based on other work that we've, been floating based on legislative changes and others, I can, I think, reasonably estimate at least $50,000 to $60,000 for the change. Because the fees are increased, they're intended in part to cover that. That's fine. I'm trying to build a record, just to be perfectly honest with you, that every time we change something, it definitely has a cost. And sometimes, we'd be able to absorb that, but all of it, we definitely can't. So in this case, fees are increased, great. Corresponds to the amount of work, wonderful. I do think it will take them at least 4 months to update the code, to execute the build, to go into UAT and have the flows tested, the upload functionality. Just the reality of the timeline. Maybe it's a little bit faster. The quote we received for the UCC API was 4 months, and that's it's a little bit more work. So maybe but I'm building in some wiggle room here. So maybe 3 to 6, 3 to 5, something like that. And so consequently, I think it would be important to have the updates on our website be delayed enough to let us do that work. Because we wouldn't want to make a legal requirement that they can't satisfy yet, right? So if you said new year, new DB registration, I have no qualms about having that built and deployed by new year. So that is it. I'm done burning up your time.
Questions for David? Thank you very much.
Thank you all for having me. Let's go. Thank you.
Katie Fuller is back.
The order was updated because of Chris, so Hillary's last. So it's Jamie next.
Jamie, would you join?
Sorry, I have to take my son to the doctor. If you need me, I'm an email away.
Thank you.
Thank you.
Good afternoon, Madam Chairman, members of the committee. My name is Jamie Feehan with Bremer Piper here this afternoon on behalf of the American Property Casualty Insurance Association, which is the nation's largest and preeminent trade association for property casualty insurers, as you might have guessed by their name. Several hundred members of whom write all lines of P&C in Vermont, including auto, homeowners, workers' comp, et cetera, both personal and commercial. And also on behalf of State Farm Insurance Company, which is the nation's largest property casualty company. Thanks for the opportunity to come in and speak to you this afternoon at H211. You may hear some similar themes to the testimony you heard from Chris Delia earlier, but from an insurer's perspective, because there are some nuanced differences, but still some similar ones. But it's important, so if you'll permit me, I may cover some ground we've already heard. Let me state at the outset that insurers are not data brokers, so we're not encapsulated by the definition either. Insurers do not treat PII as a commodity to be sold. However, insurers do access a lot of information, a lot of data, including from sources such as data brokers in Vermont and elsewhere. This information is necessary from our perspective, whether it's generated on our own part or provided by others, to rate risks, price policies, to provide policyholder services such as importantly administer claims and process claims. You've heard about fraud. That's very important for insurers. In fact, there's a requirement in Vermont law that insurers develop a fraud plan and a mechanism in terms of what to do to prevent, investigate, and respond to instances of fraud. The data that we collect is important in providing and compiling that information. So really, it's the access to information that is bringing me here this afternoon, and the ability to continue to meet those policyholder needs. We're here, I think, as you heard before, also because we're having some elements of privacy and access to information and protection of information through this bill, and not a larger comprehensive privacy bill. As you know, California, for example, had the privacy bill, has exemptions for insurers, financial institutions, et cetera, to treat these purposes. And then their Delete Act incorporates the privacy bill. So those exemptions flow through. Here, we've got a different dynamic. So we're kind of having a privacy discussion in addition to a Delete Act discussion, as well as some other changes. And I do want to recognize the steps that have been made through drafting and amendments that are trying to maybe encapsulate some of the services that I just described. But it's really difficult to try to envision or predict how an insurer's businesses on behalf of its policyholder might be impacted by either the existing exemption language or by a deletion, frankly. Because we are talking about privacy, let me just briefly explain what's in place for insurers, which are highly, highly regulated entities at the state level. Since 2001, the inception of Graham Leach Bliley, DFR has had a comprehensive regulation that the scope applies to non-public personal financial information, as well as all non-public personal health information. Requires notices to consumers about the privacy policies of a company. And I think what I'd like to leave most importantly about this regulation is significantly, it requires an opt-in by the consumer before a company can share any of their information with a non-affiliated third party. That's a standard that is very high. In fact, very, very few states have that sort of standard. So when you hear comparisons among states on treatment of GLBA, please remember that our standard is already extremely high and requires that affirmative opt-in by the consumer. There's also an accompanying regulation that requires insurers to have standards for safeguarding, in other words, the software and the platforms for safeguarding that info. We have our own regulation on record retention. Just a few years ago, a law was added to the statutes called the Vermont Insurance Data Security Law, which adds further sort of delineation and protections for personal information. And like under GLBA, it extends to third-party consultants or vendors those same obligations. So any kind of contract we enter into with such third parties makes it clear that they're protected pursuant to our protection standards, and they're not subject to further sharing. I think, as I mentioned, our biggest concern is the continued access to this information, and in the absence of that, how might it impact our ongoing procedures and policies? Take the insurance policy by itself. It's a contract between the company and the policyholder. Within that contract is a duty to defend the policyholder in claims against it or in claims, to investigate those claims for legitimate purposes, for fraud. In other words, the insurer is acting as a fiduciary. They're stepping into the shoes of the policyholder to investigate these processes. Some of these claims can take years to develop and years to resolve. So we're worried about the lack, I think, of and I struggle with this word, specificity in the bill on the tenure or length. We're worried about premature deletions that might somehow impact access to information that could put insurers, which have this regulatory scheme and obligations as fiduciaries, with regulatory consequences for failing to act in those duties at somehow risk or jeopardy. And so when I look at additional examples of how insurers use this sort of information. I mentioned legal obligations, regulatory inquiries, fraud investigations, law enforcement inquiries. Again, the deletion rules risk premature deletion from our perspective. I know that there is information or listed among the exceptions are for these instances, but again, what's to prevent, a premature deletion? I think, that is certainly an area that we want to focus on a little bit further. I mentioned the claims processing that can include some sensitive information, privileged information that has to be preserved until cases are resolved. Insurers model all the time, both for rates that they submit to the department for review and approval in terms of modeling. Those often involve personal PII. And then I could go on, but those are just a few. The concerns, again, with the language are the bill fails to clearly define the scope and duration for retaining the data. No explicit protection for privileged and sensitive data. These are for existing uses. I want to raise a little bit the potential for impacting new business. Take, for example, auto insurance. Insurers will often use a data broker to obtain from DMV a 3-year record of the driver's history. That's granted through DMV to a data broker through contract. I think, it's through the federal DIPA, Drivers Protection, something, DPPA, I forget the name. Also through DPPA are security notices, recalls, defects, et cetera. But insurers will order a few 100,000 MVRs a year at application, at renewal, to get an understanding of the risk that they're insuring. And again, it's all about being able to price the policy to the risk to match that. And in the absence of that information, it has an impact on what that price might be, and an impact on the insurer's underwriting. I recognize the exception references the existing definition for the existing business relationship, including accessing financial products. But does that include, say, an individual has asked for their information to be deleted? Is the data broker allowed to create a new file for that individual to pull the we call them MVRs, the DMV MVR, motor vehicle record? There is the exemption for FCRA, which is a little bit interesting wording, but it doesn't have sort of the clear exemptions that insurers are used to seeing in whether it's a privacy law or even in the California Delete Act. And so because of that, rather than trying to predict what that might be, I'm here to ask for a clear exemption for regulated entities, regulated insurance entities under DFR that receive this information so that we're not sort of putting at risk the continued access to the information. I mentioned the security that's in place now to protect the information, to hopefully give you comfort that it isn't sort of the ability to sell or to further share the information downstream. It's for those insurance purposes internally, and to be able to service those policies related to whether it's underwriting, whether it's related to claims processing, whether it's related to fraud prevention, et cetera. And we just think it's the easiest way to accomplish that is through a clear exemption. So I'm happy to answer some questions that you might have. I'm also happy to continue to work with the lead folks on this to see if we can't address some of these, I guess I'll call them gaps, I think, that in our minds exist. But I do, again, want to acknowledge that, the language has come quite a ways, and I don't want to left that unsaid.
Questions for Jamie?
Yeah, so thanks, Jerry. Trying to remember what the DFR rule. I was thinking between this type of legislation and the rule, or is it more that you want to be able to have access to the information that would otherwise be in possession of the data?
The latter, or otherwise might be subject to deletion and therefore not.
Correct. So it's not like there's anything inconsistent between the rule.
Well,
That was-
only that this bill doesn't really speak to the treatment. It speaks to the potential to delete it with the exceptions that are included.
Yeah, I understand.
Yeah.
You're looking at the impact.
Looking at the impact, exactly. And to not, again, we're not selling the information. We're not using it for purposes that generally aren't authorized or asked for by the consumer. But as I mentioned, some of this can hang for a long, long time, especially if claims are litigated, multi-party claims, accessing
In my head
information.
around is what that exemption would look like.
Sure. Yeah.
Because, you know, exempt all regulated industries regulated by, well, what does that mean? In terms, in practical matter, in terms of the statute. I mean, this legislation.
I mean, it's a difficult one, and I've struggled with my clients as well, and we've, fooled with it. I mean, I could even just read this, that I think we've offered, information. It would be an adding exemption, collected, used, or disclosed by insurers subject to regulation under Graham-Leach-Bliley and its implementing regulations. I mean, so that is narrow and gets to it.
Yeah, but I don't understand that because, are you making exception to the deletion requirement or
Correct.
specifically for the deletion?
Correct. And that's it. That's what this bill addresses. If we take up a Senate bill later on, I'll have.
But how would you phrase that? I mean, so the data broker has information and you create an exception on the consumer's ability to delete. But
It's,
how do you identify the specific information that you're trying to exempt?
yeah. I mean, that's information that the data broker would have and would only release it to us upon our request.
Right, they probably have a lot of information. How do you distinguish between, the universe of information you have about that consumer and the concern and the information that you're looking for?
It's the information that we would need, not to retread, we would need to be able to underwrite a policy, to administer a policy, to renew a policy,
I'm just trying to think about how that
to
would.
process the claims, to access, medical information for injuries sustained in an accident, both first and third parties. Its ability to conduct actuarial models, rating models.
But at that point, if you have it broad enough, then the consumer really doesn't have a deletion right. I mean, it'll serve the insurance company purpose, I understand. But what's left?
Well, this would be, the deletion right wouldn't apply for insurance purposes. In other words, the data broker on the construct of the bill could deny the deletion request because of the insurance purposes, as will I.
I think.
No, go for it.
Jamie, I was just wondering, as far as the processor exemption, that was really trying to get at like the business use stuff. I was just wondering if you could speak to that at all, just your thoughts of trying to navigate that and how this doesn't cover that.
Yeah, I'm a little concerned about new applications. I understand accessing, but if the information's already been deleted, are we allowed to open up, is the data broker allowed to open up a new file for that individual? We're very concerned about the lack of details on how long the tenure to be able to, like, for example, if we can use it under the existing customer relationship to administer blah, 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 blah. Does the data broker know that they may need to hold on to that for 10 years, 12 years? Could there be an inadvertent deletion request that's done sooner, thereby not allowing us to have that information that we need? It's those areas. I understand you're trying to craft to meet all scenarios that might come into play for various sectors, perhaps even including insurance. That's the struggle we're having with trying to predict that same scenario of how we need it. And from our perspective, the cleanest way to do that is a clear exemption.
It's related, if that's okay. And thank you. It's try to do all the things. I guess like and I'm not sure if you can speak to this, but I think what the trying to do an entity level under entities unregulated or under DFR. Like I put in the email where I was trying to ask people to be more specific about business rules, had examples like things like if somebody takes out a loan, but then that information is sold that they took out a loan and they might be, then that's sold to credit card companies that can use them to target credit card offers and that kind of stuff, or student or like loans that were meant for students, education financing that then those students start getting offers for different things. And I'm like, so there's certain like valid uses where you want the student to be able to take out the loan, but you don't necessarily want them to be all of a sudden marketed to by the entire different industries. As an example, but I think that happens in different cases. And so to do the entity level under entities regulated by DFR is hard because it covers a lot of different entities.
Yeah, and I may get fired by my clients, but I don't think entity level for this bill isn't as important as it is for a larger privacy bill, because we really are talking about the information that's coming. So when I say information collected, disclosed to regulated entities by DFR, that likely excludes some of the folks you're worried about.
Interesting. Okay, I'll look into that. Thank you.
So regarding car insurance, an insurer will reach out to a third party for like accidents, correct? Is there a database for that?
Yep. DMV holds that.
Oh, DMV holds it? Oh, okay. Never mind that.
And
Well,
DMV enters into contracts with entities, data brokers, to provide that information under permitted purposes under federal law, this federal DPPA that I'm mentioning, which includes driver records for insurance underwriting.
so if a person knew who the data broker was at that time, could they request the delete of that record? Or not because of the rules with NBR?
If the person knew,
Like, for example, I'm
Yeah.
shopping for insurance. I know I have like 10 car accidents on my record. Can I request a delete and then go get insurance? Which puts anti-selection, right? And it gives me a better rate, but at the end of the day, cost you all more.
I don't, in this instance, the data broker will have the MVR, but DMV is the holder of the record, so I don't think they could ask DMV to delete their
No.
driving history. So in your example, it would still be
Okay, so they go directly to DMV.
correct.
He's
And it's-
shaking his head no.
Well, he's,
And that's what I'm thinking. I don't know if it's like that current. Like for Hawaii, I think it takes a couple days to get that information. I might be wrong on that, but
well, all I know is insurance companies will submit on a frequent basis data requests to a data broker to approach DMV to get their 3-year driving record.
right.
And we're provided with that. And then what that looks like is part of the underwriting factors that go into pricing the cars.
What's the sort of requirement of the data broker that you contract with?
They're required to hold their information.
Are do they fall under the same laws that the insurance companies fall under? So are they or can they take this data that you're asking them to gather and then turn around and sell it?
Yeah, I know something about the contract that DMV requires the parties to enter into, but I don't know enough to answer your specifics about, I don't want to assume or guess. I think it likely addresses permitted uses
Right.
through the federal law and nothing beyond. Yeah.
I think that's the crux of everything, is make sure that the data broker is not, either through insurance or through banking, that they're not able to turn around and sell that data that they've been asked to gather under these specific reasons. Emily?
I guess following on that, does the insurance industry have like specific data brokers that are kind of insurance specific that they work with in order to gather that information?
I know there are a few, that are common.
And then aside from that, do they kind of just gather data from all kinds of different data brokers that are not necessarily?
There may be data brokers that have fraud information. There may be data brokers that have claims information. There may be data brokers that have health information. So yes, there likely are. But I don't know the specific universe, how they do it.
Thanks.
And it's probably for, efficient, one entity going to DMV for 250 insurance companies versus 250 insurance companies going to DMV directly
Mhm.
to get the MVR.
Yeah, no, that definitely makes sense. I definitely understand that. I guess I'm trying to get my head around if there are the types of data brokers, because if there are some that are kind of that have regulations that are pegged to your industry,
Yeah,
does that kind of flow through and the whole thing? Are there actually guardrails there, or are they like,
right.
yeah?
Yeah. And I do know, or recall again, on the contract, that those entities that do sign the contract with DMV convey the same restrictions to those that they also might share information through permitted purposes. So it may not satisfy your question you're trying to solve, but there is that two-way flow of protections, at least from the insurer's perspective.
Bear with me, folks, on this one. Our colleagues down the hall in judiciary are dealing with things related to criminal records, whether it should be sealed or expunged, which is the equivalent of deleting it or just not making it available to somebody without authorization. Is something like that technologically possible? Because it sounds like the information that is typically asked to be deleted is the essential stuff that insurers, bankers, and other similar businesses need. So isn't it possible perhaps to keep that information, but put up a firewall so that it's not available to the public?
I think that's what they do now. Pretty sure, and I'm just remembering, because we've had this discussion before, and probably Dylan can help us. But the company that DMV contracts with, the data broker that you contract with, that if I remember right, that's all they do. And there are contractual agreements, pieces of contract that require them to keep this data private. They can't turn around and sell it.
No further downstream sharing. Exactly.
Dave, just a little, I think if we were dealing with one entity that had the information, it might be different, but we're dealing with an industry of brokers. And to ensure that every single one of them, I think the more gray we put in there, the harder it's going to be to enforce the law and to ensure that Vermonters' privacy is maintained. And so I think, I love that thought. And if it was like our court system, one place that had all the information, that was a state agency, that was, that we had some, I don't know, influence over, that's so different from this vast international industry that is collecting data and, has so many different ways of maintaining it. So I think we should keep thinking on it, but I'm just not sure that it's apples to apples.
Thanks again. I look forward to continue to working with you all as this.
Thank you, Mr. Chair. For the record, Dylan Zwicky with Leonine Public Affairs here today on behalf of Relics. Relics is a data broker, and applicable Relics companies qualify as data brokers and have been registered with the Vermont Secretary of State since the data broker registration law went into effect in 2019. My testimony is going to sound a lot like Jamie and Chris's because when they spoke about the data brokers that they go to for the information, in many cases, that is a company like Relics. And I'll give one example just to kind of paint that well, maybe two, chairs indicated that data brokers act as the intermediary between DMV and auto insurers for purposes of pulling that motor vehicle report. Relics has a contract with DMV to do that, and I think Jamie was accurate in representing that there are specific uses in that DMV DPPA agreement for what that data can be used for. We can't use it for other purposes. There's additional cybersecurity, insurance requirements. It's fairly rigorous, and I would say that extends when I get into some of the other aspects of my testimony to GLBA data. The other example is if anyone's ever logged into their financial institution and has gotten the questionnaire of what road did you live on when you were 17 years old, you got to select it to make sure that it's actually, in fact, Mike Marcotte logging in. That's a LexisNexis, that's a Relics product. And so when we talk about, and really want to take the time today to focus in on the deletions aspects of H211, because it's really critical in our view that the deletion aspect not get in the way of that type of a service that protects consumers as they go to transact business in the marketplace. I want to caveat my testimony by just saying that my client hasn't had the opportunity to fully review the latest draft of H211, and so my comments are going to be relatively high level. I'm happy to continue to work with the committee as you look through this. I'm going to triple down on what Jamie Chris said with respect to some of the interaction between H211 and an omnibus privacy bill. And I think the context again is that this bill largely, I think, is intended to look like the California Delete Act. California Delete Act was put in place after the CCPA was enacted and really intended, based on my understanding, to fill kind of a technical gap in the deletion provision in CCPA. But California Delete cross-references to the exemptions included in the underlying CCPA. And those are the same exemptions that you find in, well, every state privacy law, the Fair Credit Reporting Act, GLBA, DPPA, HIPAA, data level exemptions, and totally understand the concerns that have been raised around this table over the years about entity level exemptions and opening up to some of the concerns that Representative Priestley has outlined. I also want to say at the outset, with respect to the changes of the definition of data broker, how they file with the Secretary of State, no issues. And so I kind of want to hone in on the deletion aspects of H211. And because we don't have an omnibus privacy law, and I expect the committee will take a look at that post crossover, I think it's really important that we get the different elements of H211 right. So looking at the deletion provisions in H211, the approach taken, because it's not a data level exemption referencing GLBA, FCRA, and DPPA data, it's kind of a unique and novel approach, not one that we've seen in any other law. And so rather than adopting that data level exemption, it's really trying to kind of shoehorn in use case exemptions, and that raises some concerns from our perspective. And so our requests to the committee today have been to include those data level exemptions. So, and I do appreciate some of the additions that have been made in the recent draft as an attempt to try to get at those use case and legitimate business purposes, but I want to walk through why I don't think that they kind of meet that need. First, I think the subsection C3A, the required by law language, provision reads that a data broker may deny a deletion request where retention is required by law. That term implies a specific kind of identifiable legal command. And while those commands do exist in some of those federal statutes, compliance obligations extend beyond individual retention requirements. So maintaining an accurate consumer reporting system requires suppression lists, correction histories, audit trails, accuracy monitoring infrastructure, none of which is traceable to a single discrete thou shall retain command in each of those federal statutes.
That's a question.
Yes. So I'm looking at, it's going to be subsection C3A. I can get you a page number. Yeah. So the deletion request doesn't just touch the records that are explicitly required to be retained, but it touches the compliance architecture around those records. And so when the AG or a private entity evaluates whether the denial of a deletion request was lawful, the question that they're going to ask is, was retention of this specific data element about a specific consumer required by law? And the ambiguity created by this language, I think, is a real challenge for my client. And that's why it would be solved with a data level exemption for each of those federal privacy laws. It eliminates that ambiguity because those laws have kind of a clear framework for how that data can be used, how it can be maintained, how it can't be used. They sort of set aside from the simple require language. The second subsection, I think, was added to try to address some of the concerns that were raised in C3B3. And that's the strictly necessary to fulfill a specific legal requirement by written contract. This provision has a couple of issues. First, it requires a written contract as a vehicle through which the legal application flows. But a company's obligations under FCRA and GLBA is attached to the company directly by operation of federal law and not because a client contract passes through to them. So a company is or is not a consumer reporting agency or, the GLBA covered service provider by virtue of what it does, not by virtue of what the contract says is what is covered. And so if a client contract were terminated tomorrow, the federal compliance obligations would still remain, even though the contractual obligations still there. The word strictly, I think, imposes a necessity standard when it's kind of challenging to satisfy in practice. FCRA, for example, compliance requires cross-referencing historical data across consumer files, maintaining those suppression lists and preserving correction histories, none of which can be characterized as strictly necessary to fulfill one specific contractual obligation, even though they are unambiguously required under those federal statutes. The practical effect of this is that a data broker invoking this exemption would face significant legal uncertainty about whether that retention practice kind of meets that threshold laid out. Moving on to subsection C3B6. This is the process solely in the data broker's capacity as a processor language. The word solely, I want to hone in on, a company may not process consumer data exclusively as a processor for a single downstream client. It may maintain its own data assets, operate as a controller with respect to many of those assets, and simultaneously perform processing functions for financial institutions clients. And so in any given transaction, a RELX company, for instance, might be acting both as a controller and a processor. And so the solely requirement means if a company has an independent data governance role with respect to the consumer's information, which it typically does, the exemption would be available to them. So taken together, those three exemptions show a common kind of structural deficiency. They're use case versus data regime based. And they would require companies like RELX to demonstrate for each individual deletion request that each one of those narrow subset of specific conditions applies to the specific data at issue. And this is incompatible with the federal regulatory framework laid out in those federal privacy regimes. And that's why we would request that the committee align the bill with California and include the data level exemptions for FCRA, GLBA, and DPPA. And I think just taking a step back, having watched a lot of the testimony over the past couple of months, including from regulatory actors in California, I haven't heard in that a concern that the exemptions that exist in the California Delete Act are creating a challenge for them with respect to consumer privacy. And so absent that being raised, I think we have concerns about the novel approach that's being taken in this bill. And so if I may, I just may offer a couple thoughts on path forward for the committee. I mean, I think the simplest in the context of this bill alone would be to align with the California Delete Act by including those data level exemptions, not entity level exemptions, data level exemptions for those privacy regimes. Alternatively, I think you could advance elements of this bill, the changes to the definition of data broker, the reporting timeline all seem to make sense. And recognizing that you probably will turn your attention to S71, which does include a deletion mechanism, not just for data brokers, but for anyone who holds, any business who holds consumer data, and have the deletion conversation in the context of a broader omnibus privacy bill. The order of operations here is challenging. Appreciate that without having an omnibus privacy bill in place. And I think this conversation would be better suited to have in the context of that conversation. But absent that, aligning with California might be the right approach.
Dylan, do you have stuff in writing that I tried to take notes, but
Yeah,
okay, cool. Thank you.
I can provide that. I wanted my client out to review it, so it'd be a couple days.
It's data level or industry level, or is there legislation that blends them? Is
For the state privacy law landscape, I think there's a variety of different approaches. And I see merits on both sides of the argument with respect to some of the challenges that have been raised for entity level exemptions. But in previous privacy conversations, including in this building, I think what we've heard from individuals and advocates is that a data level approach is more protected because it doesn't cover an entire entity. And so that's why we were trying to respect that general line of thinking in suggesting that
if you're more productive of
the consumer. Yeah. But this use case is, we're having a hard time wrapping our heads around exactly how it'll play out, and the uncertainty and ambiguity there is a real concern. For the reasons that Chris and Jamie laid out in terms of if a data broker doesn't feel like they can reject a deletion request, or that they are obligated under the framework here to delete data, that does have downstream consequences to financial institutions and insurers and others that use our services to kind of verify identity, prevent fraud, underwrite insurance policies. And I think we're trying to avoid that.
Is you're sending the statement, right?
Yeah, I want to have this is just
Yeah,
my
that's fine.
chicken scratch. I would
That
point to my client.
your suggested amendment?
Yeah, I can share the suggested amendment well in advance of the written testimony, but I have to
Oh, okay.
both.
Questions for Dylan? I think so. Steve.
I think Hillary and
Where's it,
Steve
Hillary?
just swapped again.
Oh, okay. Hillary.
Remaining dynamic.
Good
Hi.
afternoon.
Good afternoon, Chairman, members of the committee. My name is Hillary Borcherding. I am an Assistant General Counsel at the Department of Financial Regulation. Thank you for this opportunity to speak today. I'm here today to testify in support of the change to the definition of personally identifiable information in Section 2430 and in support of the amendments in 2435, the Security Breach Notice Act, as well as to talk additionally about the proposed change that didn't end up in this draft, which is to the enforcement mechanisms under the Security Breach Notice Act related to the department. I'll say at the outset that there's been lots of conversation today about the data broker provision and how that might impact regulated entities at the department. I am not prepared today to speak on that topic, but I will raise the issue with the department and the divisions, and we can provide additional context and insight if that would be helpful. As background, the Security Breach Notice Act includes dual enforcement mechanisms. The Office of the Attorney General has comprehensive authority to receive reports about data breaches and to investigate and enforce each data breach. The department has concurrent authority with the Security Breach Notice Act related to entities that are licensed or registered with the department. Last year, the department reviewed 116 data breaches impacting 68,000 Vermonters. Roughly, I should say. The amendments we support today are based on the department's on-the-ground experience investigating breaches and bringing enforcement actions when necessary. I wanted to briefly walk through the three most substantive changes, but at the end, feel free to ask questions about any of the changes we've proposed. Currently, the Security Breach Notice Act states that a breach occurs when there's been exposure. I mean, this is a very rough summary, but exposure of personally identifiable information. And that information is defined as a consumer's first name and last name, or first initial and last name, in combination with one of the enumerated elements that we talked about a little bit during the walkthrough. Our concern is that we have had entities who have given preliminary notices to us and then said, actually, this wasn't a data breach because we lost someone's social security number, their bank account number, their mother's maiden name, and their birth date, but we didn't lose their name. I mean, I'm hyperbolizing a little bit, but the example is that you could lose multiple elements in combination on that list. So long as you don't lose their name in connection with it, it wouldn't be considered a breach that would be reportable to the department or to the consumers that are impacted. And that was the concern that we were trying to mitigate here. There are other ways that other states have mitigated this, and I can talk through some of those if it would be helpful.
Do you want to hear what other states are?
Well,
yes,
sure. Okay. There's one example from Georgia that I thought was helpful. They had essentially the same definition that we have in our existing law, but then they had a catch-all provision at the end that said any of the data elements contained above, when not in connection with the individual's first name or first initial and last name, if the information compromised would be sufficient to perform or attempt to perform identity theft against the person whose information was compromised. That might mitigate some of the concerns about the change being overly expansive. So I would be happy to send that language over if that would be helpful.
Yeah, I think it would be. Yeah. Thank you.
The second amendment that I would talk about is the HIPAA exemption provision. The Security Breach Notice Act exempts some breaches related to HIPAA data from compliance with our rule. And this is based on the rationale that they have existing compliance under HIPAA, which is reasonable. However, failure to notify the AGO and DFR of these breaches has prevented the AGO and DFR from being able to understand the scope of exposure to Vermont consumers to make sure that those consumers have information to be able to respond if we get complaints from consumers. So this amendment would continue to permit these entities to comply with HIPAA notice requirements as they relate to consumers, but would provide the AGO and DFR with an opportunity to make sure those notices actually happened, and also make sure that we have sufficient information if consumers reach out to our different departments asking for questions about breaches. The third amendment that I was going to focus on is the one that isn't contained in the current draft. And this is a change to the enforcement authority of the department. Right now, the Security Breach Notice Act reads that any entity regulated by the department has to report a breach to the department. But the department only has authority to investigate and enforce breaches related to entities that are licensed or registered with the department. This creates a not quite perfectly overlapping Venn diagram where entities that should be licensed by the department but have been conducting unlicensed activity, we can't investigate or enforce against those entities. Also, entities that are SEC registered entities and just notice file with the state, we can receive notices from them, but we can't investigate or enforce if there's a breach under the act. And so what this amendment is doing is attempting to close that and make it a perfectly overlapping Venn diagram. And those were the primary changes that I wanted to address today and show support for. But if you have any questions or you'd like to talk about anything else, I'm happy to stay on.
Great, thank you, Hillary. Thank you for sending that over to us.
Thank you.
Steve? No?
No.
Was he on before? No, we never joined. Okay. So that is it for witnesses for today. So tomorrow, 9 o'clock, we're here from our legislative interns. When we come off the floor tomorrow morning, H211. And then we're looking at H385 tomorrow afternoon to wrap up our week and wrap up before we go on a little hiatus.
2:05, you said. And what did you say? What do we do?
So we're delaying 2 legislative days on 205.
Okay.
2
or 3?
2.
2.
So
Tuesday.
tomorrow and yeah. Right. And Zach, do you want to testify today or do you want to wait till tomorrow?
Am I the only one that's going tomorrow or?
No, there's less more tomorrow.
Okay, then I'll probably, I guess, would wait till tomorrow.
Okay.
Just.
Okay, that's fine. So I think that ends our day today. We're on the floor at 3:30. Tomorrow, H512 will come up. And I think the reason why it's been on notice for 2 days is because it's a short form bill. So it has to sit on the calendar for 2 days. In case anyone's wondering. So, any questions, committee? Okay.